Good morning, everybody. It is a little past 9:30, and we're going to start the work session on House Bill 105. I'd like to introduce Representative Lekis and Representative Bailey, who are members of our subcommittee this morning. And we have Representative Grassi and Representative Fitzpatrick. So we had a lively hearing on House Bill 105, and as a result of the input that we had from the hearing, it was decided that we might try to amend the bill and went through different iterations of it. And I am introducing to the subcommittee an amendment, which essentially takes out Section 2 and leaves Section 1 and creates a record retention for 7 years for the hospitals and for birth centers. So I'm going to pass this out to actually, Representative Bailey, will you do that? That said, we did speak with the Secretary of State and with Department of Health and Human Services. We would like to continue looking at Section 2 of the bill and work on it over the summer so that we can address some of the concerns that people have about privacy. It was discussed. There was a Senate hearing yesterday on the bill, and an amendment was offered to transfer the vital records from the Secretary of State to the Department of Health and Human Services, and it was not accepted by the committee, and it was opposed by the Secretary of State's office. So, based on the fact that our Constitution says that the Secretary of State, actually, is there someone here from the Secretary of State's office? Would you like to speak on that? Just so that everybody's on the same page, because typically what happens before subcommittees is we have all these conversations. So I would love to have somebody from the Secretary of State's office explain this.
Good morning. Thank you very much for calling us up. My name is Erin Hennessy. I am the Deputy Secretary of State, and with me today,
I'm Kristen Keniston. I am the new state registrar.
thank you for the question about the Constitution. So in New Hampshire's Constitution, in Part 2nd, Article 68, it says that the records of the state shall be kept in the office of the Secretary. This includes the vital records in the state, and that's under RSA 5-C, :3. The policy in state law does identify the Secretary of State as the keeper of the records of the state and includes the records of vital records and the data associated with that. And I also want to emphasize that our state law says that we are the keepers of the records, but also while assuring the privacy of all New Hampshire citizens. So that's the privacy piece is something that we take very seriously. In addition to the vital records of the state, we are the keeper of all records of the state. This includes all the records for all the physical records. We have over 100,000 boxes that we keep in our Division of Archives and Records Management. And that number grows annually, as well as the number of electronic records that we maintain for the state continues to grow. I'm sorry if I'm continuing on and too far down a rabbit path about what the records management that we do for the state is.
And the conversation that we had was that over the summer, we would meet with your office so that the concerns that people have over privacy are addressed, and that the records are useful for individuals but at the same time, and for other organizations, but at the same time,
Yes.
the privacy of our citizens is protected.
Yes. And we are happy to meet with the committee whenever you would like over the summer. We're here all year round, so whatever works for you works for us, and we're happy to show you, take you to vital records. we won't show you any of the private information, but we will, we have a vault there of actual physical records, but we can chat with you about the actual privacy and how we do that within the department. And I'm sure that DHHS can share that with you from when the information is transferred to them as well.
Do you have a question, Representative Lopez? Okay. Do we have any questions from the committee? Yes.
Thank you, Madam Chair. So I've already shared my concerns with some of your people, Madam Secretary, and I don't know whether we're going to have an opportunity to talk about your thinking in response to some of the concerns that I've raised. I don't know whether that's been communicated to you. I've been talking with Director Tilley, Ms. Rogers, Chow, whom I know from my time on the Vital Records Privacy Board. So the question is whether you have some proposals, because if you've discussed my concerns with them, which I suppose you have, then you know that I'm looking for some assuredness that one bad apple cannot get into a situation where the very conscientious and competent work of both the Secretary of State's office, but also DHHS, to keep these privacy concerns uppermost in your mind when you're dealing with people's confidential and very often sensitive information. I served for something like 5 or 6 years on the Vital Records Privacy Board, so I know the issues well. I'm not blind to the tremendous need for this data to be available, and the screening that's being done that is protected newborns from very, very serious medical complications if left unrecognized and unattended to. So I understand the value of statistical data and so forth and so on. By the same token, that questionnaire that has the name, the address, all the identifying aspects, has also all that sensitive information on it. And that in itself, to the degree, and that has to be processed by a human being. That can't be processed by a computer, because you have to put it all into the system. Then you can segregate out the information that doesn't need to be part of the identity. Doesn't make any difference in terms of disease or something. The disease or medical issues, that's something for the doctors, for the medical side. The statistical side is something for the statisticians, but that questionnaire that has all the information and especially the identity before it's de-identified, that's potentially, and I know, because I haven't had personal experience, but in my career as a legislator, I've had experience with situations where bad apples have betrayed their trust and had devastating impact on certain situations. So that's what I'm concerned about, whether there's not some way to further reduce, because I understand the sincerity and the protections that are out there, and I respect that. The problem is to the degree that somebody violates the confidentiality and the trust of the public, and the presumably take an oath or something like that to maintain those standards. To the degree they betray that, now the damage is done. And we've seen it in the field of espionage, right? One spy betrays the whole system. And so to the degree that you are thinking and your colleagues are thinking about further ways to protect people's privacy so that embarrassing information, but nevertheless vital for the system to know, cannot be attached to, left attached to the person's name. If you can do that, that would be very helpful in my view. So thank you.
Thank you.
don't believe there's any other questions at this time. And Representative Schmidt, we agreed that we would hold I'm going to call it an informal study. EDNA is going to meet with the Secretary of State and the Department of Health and Human Services to address your concern. Would you like to, would someone from DHHS like to speak? We have a question for someone.
In particular, somebody who has an interest in this from using the data for medical research and other related things.
Good morning. My name is Tricia Tilley. I'm the Director of Public Health.
Good morning. My name is Jiahui Chola. I'm the Bureau Chief of Public Health Statistics Informatics.
Okay, thank you. As Representative Grota said, we're looking, the privacy part we plan on removing for now and then looking at working on that over the summer. But I have a question. If you don't have a good answer to it now, that's fine. You can give it later. And that is, the bill as it came out of the Senate had no address information provided, which, the public hearing we heard was a problem because then the only location information would be where the birth occurred, and that wasn't granular enough an area to be useful. On the other hand, there's a number of us concerned about privacy who really have a problem with the actual address being provided and find that problematic, let's just say. The question is, if the data that was provided didn't have the full address but the zip code, would that be granular enough for the research and other purposes that you'd want the data for?
So thank you for the questions. First of all, DHHS under the statute is responsible for releasing health-related research under the approval under the Vital Record Privacy Board. So each individual application, including the continuous use of the data, will need to go to the Vital Record Privacy Board, for review and approval. In terms of the data elements that are selected in the application based on the study needs, the board members look into each individual element and submit questions or have questions on whether the justification is good
But
enough.
I understand that, but what the question is, if the data that was, the Secretary of State's office would get data required for to create a birth certificate, whatever that is, and I know there's a problem with the bill as amended by the Senate in that regard. But if we had a bill that did not make the actual address data available at all, and if the DHHS, if Secretary of State Vital Records needs it for the birth certificate, they would get it. But it would not go beyond that to anyone under any circumstances. And the question is, if that were not available at all, would you still have enough data to do useful research?
I would say no, because we do need to have full addresses, not just for research, but for our internal program purpose. Like you may heard on newborn screening, we do need to have the address in order to match the person. But back to the research question, it depends on the research study design. If the study design is to look into each individual with the interview, they do need to have the actual address in order to perform this kind of study. So it really depends on the study design and whether the study will need to do record by record to have those full or partial personal identifiers for their research.
And I would just add, as Chao-Wei mentioned, not only is there concern around the studies and the health component of this, but also the department would require that address information for other areas of the department, for functions within our Division of Economic Supports, within our Medicaid fraud investigation. There are other opportunities within the department where the address is really important. So I think that that's a perfect thing for us to talk about in the summer to drill down to more detail.
Okay, thank you.
I think Representative Luck that's why we want to understand how all this information is used.
Yep.
Because it's all, it sort of spins out into different things, and we have to we have to understand what it's being used for, and then it's our discretion whether or not that's the issue.
Yeah, just one related thing, and that is, I mean, hopefully you have, control where the data goes, and therefore hopefully you have an idea of what all this data is used for. So if you could put something together, if it doesn't already exist, saying each one of these data elements and what are they actually used for?
Thank you. We've begun that, developing that table to understand. And, I think Dave Wieters and others can provide a robust description of our access policy around who can have access to what components of the data for what business purpose. So we've begun that work. We're happy to share that as we continue and to be informed by what happens during the summer study committee.
Sure. Just quick. And that if as you put that together, you have, some useful version of it. If you could send it to the committee so we can look at it before we actually end up meeting. So.
Thank you. Yes, we've begun that certainly from the health component,
Yeah.
what data elements are for what, and we're getting a comprehensive list throughout the department of which elements are used for which programs specifically.
Okay. Thank you.
Thank you, Madam Chair. Representative, I just wanted to point out, I live in a community that technically shares a zip code with another town, and we are separated by a river. Obviously, some of the environmental issues on one side of the river would be quite different than environmental issues on the other side. So I think just using a zip code would not be effective for even a study that's trying to keep the individual anonymous.
I get that. I mean, there's that, and then there's also if you have a zip code with few enough people, then it's not effectively anonymizing either. So there's issues on both sides. And as Representative Gross said, we need to understand how the data is being used, and then there needs to be a policy determination of the trade-off between what they want to use the data for and people's right to having the data. And maybe, people can opt in for parts of it or whatever, but we can try and sort that out. But yeah, I get it.
Representative Grassi.
Yeah, I'd just like to point out additionally in this case is that a lot of times we need that address data because particularly when you're looking at a case of a contamination of a well or spillage or something, if without that data, you're unable to pinpoint the source. You can say it's a zip code, but that's in a whole community. And if it's just a dump site in one area that's causing a problem with premature or low birth weights or diseases that children are having at birth, they're finding at birth from these children, we try to identify the source. And without having addresses, you can't identify that source.
Right. There's a lot of issues we'll have to look at. So.
Representative Schmidt.
So what is your intention, Madam Chair, with regard to processing the bill? Because, it was made pretty clear to us in the initial hearing that the bill as amended by the Senate just doesn't work in a totality anyway. A birth certificate with no name of the child, no name of the parents, no address is not a birth certificate. It's just an interesting statistic. But who this is kind of like a mystery. So clearly the bill can't go forward, in my view, in this fashion. So what is your intention with regard to voting this out?
So the subcommittee has been presented an amendment, which I emailed to the subcommittee yesterday, which I just gave to you.
This is your amendment you're referring to?
And it basically includes the decriminalization of entering your birth weight incorrectly, and matters like that. It does limit the retention of birth worksheets at both the hospital and home birthing centers for up to 7 years. And that's essentially the bill.
Right.
Over the course of the summer, our committee will meet with DHHS and the department and Secretary of State, and we'll drill down into the data so that we understand any kind of privacy concerns that we might have and either put in legislation or not. I don't know what the committee will decide.
Mm-hmm.
Representative Grassi.
Yeah, one of the questions I had, and I'm glad the folks from DHHS are here, is that if we limit this data for 7 years, and at that time the data would be disposed of, would that limit your ability to probably track illnesses which may not manifest themselves in the first 5 or 6 years of a child's life, but would show up later in life?
Actually, okay, it's just that the birth center and hospital doesn't have to keep it. Vital Records would keep it indefinitely. So the data is still there. It's just who has to
Okay,
hold it.
I just wanted to make sure that somebody's keeping that data and we're able to fall back on that data if we need it.
This, in fact, is another way to protect privacy and security of the data, that you don't have data sitting in another location indefinitely. It would just simply require Secretary of State's office to maintain the data, and we would maintain the data along with our data retention policies.
Okay, so I have a question on this. All the records that the birth centers and the hospitals are keeping now, does this allow them to delete that data? How is that? What's the, what would the hospital do with the MVS? Hi. So I just don't want it to appear in a dumpster someplace. I'm sure there must be some sort of record retention or record deletion, but I'd like to know what that is.
Good morning, Madam Chair. For the record, Paula Minahan, Hospital Association. This, the 7 years coincides with current law relative to the requirements of hospitals to maintain records. So that, and I did talk with Deputy Secretary Hennessy this morning. So that this is fine. The 7 years, we're fine with that. And yes, after that, what typically happens, my understanding, is they actually put it in their own archives, or they may actually delete it, but they don't have to hold the actual record in their EMR, in their electronic medical record after 7 years. But this is consistent with current state law.
Okay, thank you. Does anyone have any other questions? Representative Lucas?
Yeah, just wanted to confirm that the way this is worded would allow hospitals and birth centers to get rid of all the back data that's, more than 7 years old, right?
I believe so. You know what, I should check with experts at the hospitals to confirm that. This is the first I'm seeing of this actual language, so let me verify that. But I believe that that is the case. They could eliminate it.
Okay, another question. I mean, the data, the records that are kept now and would continue to be kept for at least 7 years, I mean, are they entirely or for the most part kept in electronic form, or they're actually paper records kept?
Electronic primarily.
Yeah.
Yep.
Okay,
Yeah.
thank you.
But it's all part of, a lot of this data is in the electronic medical record now.
Okay. All right, thank you. And I assume any personal data that is gotten rid of that happens to be in paper form is appropriately destroyed?
Yes, they follow very strict HIPAA requirements, federal and state law,
Okay,
relative to privacy. Yes.
all right, thank you.
Where we have another minute or so. My understanding is that New Hampshire is quite different from the rest of the country in terms of, basically it's 49 states on one side and New Hampshire on the other, with regard to the fact that we have stuff being held by our Secretary of State's office that is handled differently in other states. But that our system, it works at least as well, or perhaps even better. And are we looking at what other states are doing with a view to getting closer to them if their system is better? Or can you speak to that? I mean, Paula, you may not be the person to talk
I
about
don't
that.
believe I'm the right person to answer that.
Well, then maybe somebody would be the right person.
Does anybody want to answer that? Is there anyone who can? Nope. Okay, well, we'll keep that one for the summer.
That's fine by me, as long as we're not leaving it lying there.
Nope.
In the dustbin.
Never.
Make just a quick comment. And one difference about New Hampshire is we actually have in the state constitution something that specifies where the records are kept. So that is I think that's a major reason why it is different here. So.
Okay, I'd like to move amendment 2023-1728H. May I have a second? Chuck, okay. Is there a further discussion on the amendment?
I just have a question. Procedurally, Representative Grassi is not listed on the subcommittee. Is he entitled to?
He's here, yes, because he is representing Representative Wilhelm, and the paperwork hasn't been updated.
But he is on the subcommittee?
Yes.
Is this the section one referred to,
Yes.
which would then eliminate all of
No, this,
pages and pages of stuff?
no, this is, it keeps this and eliminates all this, that's right.
Yeah. Okay.
Right, but we're decriminalizing, that's
Yeah.
right.
Okay.
So, okay, amendment 2023-1728H. Is there a discussion? Nope, all those in favor? Opposed? Okay,
I'm not either.
no, that's okay. And then, I move that we recommend OTPA to the committee. May I have a second? Okay. All those in favor? Opposed? Okay. Thank you. This concludes the subcommittee, unless anybody else wants to share something else. I'm going to close the hearing. Subcommittee workshop. Okay. Thank you. Hi, everybody. It's 11 o'clock, so we're going to start the work session on OPLC organization on November, geez. On May 22nd, we will have a hearing on a non-germane amendment that we're going to put together based on the committee work that's been done in work sessions. I wanted to, I have a list of things that I've been keeping track of, and I wanted to go over several of the things that have been brought forth to our committee. And Mr. DeJoy is here because one of the something that he'd like to see is and we've received a lot of notes, a lot of emails, is about the social workers compact, which is something that we could add to a bill if we wanted to as part of that amendment. So I asked him to, he's here to answer any questions that the committee might have on social workers compact. So is there anyone that wants to ask a question about that? No? Well, it was a bill that oh my goodness, hang on, sorry. It was in a bill, Senate bill, a House bill it was Representative Shapiro's bill, House Bill 428. We retained, and we could attach to, we could include it.
I mean, I have an issue with the compacts in general,
Yes.
and I know that Representative McGuire does as well, but I don't have any specific questions, I don't think, about this one.
Okay. Does anyone else have any? Okay. So, do you have any new information or things that might prompt people to ask questions about the social workers compact?
Thank you, Madam Chair. I'd like to think I can say things that would prompt people to ask questions, but it's a pretty high bar to reach. What I would say is that you've all received information from social workers in the state. We asked our members to reach out to you, not with a form letter, but to explain to you how this compact would in fact impact their practice. And so that's what we've asked them to give you. I think as you can see from the volume of the correspondence you received, this is an important issue for social workers. That's why this compact has come forward. That's why we've brought it forward outside of regular order where it would have been introduced as a piece of legislation. It's so important for portability of licenses, for bringing social workers into the state. It's important for military families. It's important for our members who live on state borders and may have to maintain multiple licenses to work in Vermont, Massachusetts, and New Hampshire and Maine. And it's an expensive proposition as well as a time-consuming proposition. In terms of, I know folks have asked for data, and I have shared data regarding the Nurse Practice Act, and that there was a 25% increase following the compact introduction and acceptance, 25% increase in the availability of nurse practitioners in this state. We reached out to the Council on State Governments. They have been coordinating this effort nationwide. They've held the meetings in DC. They're the ones who helped to bring all the states together to put this forward. We asked them for this data, and they indicated that that's one of the problems, is that there is no data in the country regarding the impact of some of these practices. What I will say, and I understand Director Courtney will be here a little bit later, what she has said to me, not to put words in her mouth, is that the compact, and she negotiated this compact on behalf of New Hampshire, the compact for social workers as it's put together is very similar to the nurse compact in that it is a true multi-state license. So when social workers are licensed in New Hampshire and they go to another state, they can begin practicing. They don't need to apply for a new license. When a social worker moves to this state from any other compact state, they can also begin practicing in New Hampshire. Has significant impact on telehealth, the portability of clients being able to keep their clinicians if they're in college, if they move to a different state. So it has a lot of significant impacts on practice. Finally, I would point out that last session, this committee adopted the Mental Health Compact by a pretty strong vote. A number of you were here, a number of you weren't here. The reason I raised that is that the mental health counselors are part of the same board of mental health practice that social workers are. With one specialty having a compact and another specialty not having a compact, it puts social workers at competitive disadvantage in terms of the field and the portability of their licensure. I won't get into, again, the benefit of being one of the first few states. I've talked about that. I'd be happy to answer questions on that, but that's what I have to add.
Okay, thank you. I think
Thanks.
we have what we need. Thanks. So I'm just looking at the things that are easy to discuss. One of them has to do with in statute, it doesn't state that mental health boards have to have public members that are independent from the practice of mental health. So we are going to put language in that, and I've asked OPLC to make sure that all the other boards have that clause to be sure that board members, the public board members of any of the boards at OPLC are independent. So that will be something that we will be putting on the non-germane amendment. The other has to do with a career ladder for LNAs. There was LNAs are an entry level type of a position in the field, and we'd like to see what kind of advancement could be made between an LNA and a full practicing nurse, so that there's a career path for women, for individuals who are men and women who are LNAs. That's something that will be in the amendment. The other has to do with telemedicine, and it's an amendment that Representative McGuire, which allows telemedicine or telehealth, anyone practicing in New Hampshire be registered, licensed, or certified by the licensing body before they can do that. So that's going to be that will basically cover telemedicine for all practices. We don't think that we need the merging of the mental health boards, which is something that had been in House Bill 2 that we had looked at. We believe that the language in the amendment to House Bill 655 addresses that. There is a concern, though, for making sure that we have strict delineation between investigation and adjudication, which is something, Attorney Osterhout, do you have a comment to make about that? Because I know that, so recently in one of our House bills, there is a Senate amendment that defines allegations and complaints. So I just want to make sure that whatever we do doesn't, that we have some continuity between those things, if any.
Good morning, Douglas Osterhout, General Counsel for OPLC. I have a comment, but I don't know how helpful it is. So we just came from the hearing on Senate ED&A on an amendment to HB 532. And there was testimony on both sides on that very specific issue. And they were working on draft amendment language. So right now, I don't know what that looks like until I see. And that's where Executive Director Courtney is right now. She's over across the street.
So whatever changes, I just want to make sure that we
Right.
don't collide or step over each other
I-
in crossing amendments.
I agree with that, but I don't know what's going to be in the amendment at the end of the day. Is the issue. So I think it's something, once we see that amendment language, we can flag it and make sure everything works together appropriately.
And who's writing that amendment language? Do you know?
It's not me. I
Okay.
don't know.
I'll check. Okay. The other, those are really the main points that I wanted to make. We are going to be sure that there's in statute a delineation between adjudication and investigation. So that means that will be clearly defined. And in House Bill 655, there was a lot of there were a lot of changes to disciplinary actions on the part of the board. So we want to make sure that that language is properly identifies who's responsible for what. Yes, Representative Lucas.
Yeah, one thing I was just looking at House Bill 655. So I guess the Senate committee, their recommendation was ought to pass without any amendment, and I believe the Senate will be voting on that tomorrow. So we probably know what that's going to be. Could change, but we should know in a day. And then looking at your list, I mean, there's some other minor ones. Telehealth for PAs, I guess we managed to leave them out.
Well, I think what we do with telemedicine and telehealth in number 9 at the bottom,
Yeah.
will address them.
Okay.
Yeah. We still have to, another issue within the OPLC realm is the medical review subcommittee, which do we want to put that in the non-germane amendment, or do we want to wait until we have more time over the summer? And I see Director Courtney is here.
Actually,
Don't sit down too soon. Okay.
I have a question.
Yeah.
I'm not really clear on what the medical review subcommittee does, what it is.
Well, maybe that's a very good question. And maybe, so can you explain to the group what the medical review subcommittee is
Yes.
and how we need to address the issues with that group?
Certainly. Thank you. And I apologize for being late. I was at the Senate. So the Medical Review Subcommittee is a body that's created in statute. It's comprised of primarily physicians, but also, I believe, a PA and some public members. They are appointed by governor and council, so they're independent of the Board of Medicine, and their charge is to essentially investigate claims. There have been issues with the MRC reaching quorum. I think in the last year they've met 50% of the time, and the individual members on the MRC have reported that they are only able to review about one case per month. We receive over 200 a year. So doing the math, obviously, that doesn't work, which has created a backlog. We have worked with the Board of Medicine to create some sort of workaround, a different process to the extent that we can through statute to move these cases along, but there still remains a backlog. My suggestion, and I believe, and Dr. Baker from the Board of Medicine is here, I believe the Board of Medicine has voted on this, but my suggestion is to proceed with a non-germane amendment. Eliminate the MRSC, establish the ability and rule for the Board of Medicine to establish an investigative committee that is accountable to them, because that's the other issue here is once you're on, there's no way to get you off other than going through the impeachment process, even if you aren't able to attend and satisfy quorum. I think time is of the essence, given that we have cases that are backed up, that are ready to be reviewed and are just waiting to go through this process. And we would support a non-germane amendment sooner rather than later.
And Representative Schubert has a question.
Thank you, Director. You stated that the review board is only handling one case a month approximately. In your opinion, why is that?
So they've reported that they can review, each member can review only one case per month because of the time commitments, which is just not sufficient with what we need to do in an investigation.
Oh, sorry about that. So do you know what the logic was for creating the separate medical review subcommittee when it was created in statute?
Yes, I would defer to Dr. Baker more on that one, but my understanding is it stemmed from an audit, I believe in 2012. And it had to do with separating the duties, the investigative duties from the adjudicating duties, which we fully support. That's very consistent with what 655 proposes. And the Board of Medicine also supports that. I will say that the Board of Medicine, more than probably most regulatory boards, is very cognizant of their need to separate those two functions. The issue here is how it's been implemented and the fact that there's no accountability. If they were able to establish a committee and rule, theoretically they could promulgate rules that would set forth the membership requirements such that, oh, if you miss 3 meetings, you're off and you can appoint somebody else. And that seems to be the issue.
Okay, follow up. And so if a complaint comes in about concerning a doctor, then it goes to the medical review subcommittee first? Is that how it's supposed to work?
How it's working now is that we receive a complaint. The office will review, determine whether or not it states a claim of professional misconduct. If it does not, we send it over to our physician investigator, which is a contracted physician. If he agrees, we send it over to the Board of Medicine, and the Board of Medicine can dismiss. If the office and the physician investigator agree that the complaint states a claim, it gets assigned to an MRSC member. We'd like that MRSC member to work directly with staff because staff are in a position to conduct interviews, gather records. That hasn't really fleshed out at this point in time. The MRSC largely relies on record review and not necessarily interviews and other investigative processes. So we're still working through that because this process is fairly new in our attempts to kind of get through this backlog and work around, not around, but be creative with the statutory requirements. But that's essentially the process now.
So would the language in HB 655 change this at all?
Well, that's an interesting question, Representative. And we haven't flushed it out legally because it does appear to conflict with the Board of Medicine Practice Act. So I think one could take the position that if 655 were to pass and it conflicts with the establishment of the MRSC, that 655 supersedes that and the Board of Medicine doesn't necessarily need to utilize the MRSC. The problem is and I don't want to speak for the board, but I understand the board's concern is that they do want an investigative body comprised of peers to assist staff. And that's the issue. So MRSC does fulfill that function when it's working. And if we were to rely solely on 655, we wouldn't have that investigative body of peers.
Okay, and so if you end up with as I understand it, a subcommittee of the Board of Medicine doing this, does that end up creating conflating the investigatory and adjudicatory functions?
I don't think so. The way we envision it is that we would pair staff investigators up with a peer review investigator, if you will. Many cases don't require expertise. I don't like my Jello case or somebody murdered me case. That may not be something that requires medical expertise. But a lot of cases do. And so what we'd like to do is pair them up with a physician investigator and have them basically work the case up in tandem. Physicians by training are not necessarily great at interviewing witnesses. They may be fantastic, but they may not feel comfortable. So that's why the staff expertise comes in, and staff, on the other hand, don't have the expertise of a physician. So we think that collaboration is important.
Okay, thank you.
Okay, Representative Schuett.
Thank you, Madam Chair. Director, in your experience, have you seen complaints that would possibly cross the line? Where it's difficult to determine whether it would require expertise in the field as opposed to administrative problems, or is it pretty clear cut?
I would say it's pretty clear. I mean, it's the same legal standard that applies to any civil case as to whether expertise is required or not. So, and we do
Just
have.
curious if it's possible to craft something that would specifically delineate one as opposed to the other.
Possibly. I mean, I think that's why we have the physician investigator too, because I'll give you an example. Sexual assault, that to me off the top of its head may not seem to be something that requires expertise. However, if the examination requires you to do X, Y, and Z, which is perceived by somebody to be an assault, but is actually standard of care, we wouldn't know that unless the physician was able to opine on that. So that's why I think it's important to pair the two. After talking to the physician could say, yeah, no, that's not an expertise. That doesn't require expert testimony.
So what you're saying is that we would replace the medical review subcommittee with something like a peer review group, right?
Yes.
And is Dr. Baker, do you have comments on that? I think she's.
I'm not good at this. I think I got it this time. Hit the button right. Yeah, the board's interest is to have like a
Sorry
separated.
for the video. Could you please identify yourself?
bad.
I apologize.
I'm Emily Baker. I'm the current president of the Board of Medicine. I'm a practicing obstetrician gynecologist up in Lebanon. And I mean, the functions that we support are separating adjudication and investigation, which is a function has been in the past super effective by the MRSC, and Representative Executive Director Courtney actually told you what's going on now. So the two things we have talked about is it's not really a peer review committee necessarily, but because it's going to have we prefer public members to be on it. And the investigation would then come to this group. And just like this deliberative body, you work on the collective wisdom of the individuals who've done the expertise, can present to the board their opinion. And the board doesn't necessarily agree, right? We've had stuff come to us where they said, do discipline, and we didn't. And they've had some the other way around where we said, nope, discipline is really important from this. So it's having a group that can look at the investigations done that have been done with the assistance of the staff, and then look at each of them and use the collective wisdom of the group to come up with a recommendation for the board.
Okay, so this actually is very similar to what we're going to be doing with other boards, whereas OPLC is going to be doing the investigation because they're going to be the investigatory arm, and the boards will have a disciplinary. And what we're saying is that to help the OPLC do the investigation, there'll be physicians who they work in tandem with. And will those, is that, I see everybody, well, I see some people shaking their heads. So I'm thinking that okay. So how do we put that in statute? How do we, you have a question? Yep.
I do, and that is, my understanding, and I'm checking to see if my understanding is correct from what Director Courtney said, was that this peer review group would be made up of a subset of the members of the board. Is that correct or not?
No, and I think it's important in order to keep the functions separate, that they would be people appointed by the board. And we have some draft language that would essentially give the board rulemaking authority to establish this committee. And I think you could make that statutory change in their existing rulemaking authority.
Okay.
One of the things that's important when we look at both of these bodies is to make sure there's a distribution of different kinds of specialties. If you have 6 cardiologists, you're getting nowhere. And it's true both for the current MRSC and what any group, we would have to look carefully at the membership to make sure there's adequate distribution of expertise to be able to form recommendations to the board for discipline, for confidentials, letter of concern, or dismissal.
So would all that be in rulemaking? Okay, because I want to make sure that what concerns me is that the Board of Medicine will be appointing the people to the, whatever this thing is called, let's just call it a peer review. And I just want to make sure that there's no relationship, let's just say, between the Board of Medicine and those people that are appointed to this board that's supposed to be independent. So how does that create that?
Yeah. That was my concern too.
Yeah, that's a good point. You could have, and I don't want to speak out of turn without thinking, but you could have a process where the OPLC has to also approve of the appointed person, such that if there was, theoretically, I want to appoint my brother, we could object and not approve it. You could have, we've seen that in other statutes. I would say mechanical statute has a similar arrangement, not with respect to appointments, but with respect to actually there's his fees and other certain charges that mechanical board has, where the board is able to perform certain functions with the approval of the executive director. You could phrase it like that if you wanted some, additional.
Is the mechanical board process in statute or is it in rulemaking?
Well, the mechanical board, I just referenced the fact that there's a 2-step process. It's not, it doesn't have anything to do with committees. It actually has to do with fees and other rules that they enact. But the language is there such that there's a little bit more oversight that you could allow for in this circumstance as well.
So before you came to the meeting, I just want to make sure that you understand that I told the group that we're going to have a hearing on a non-germane amendment regarding these things on the 22nd. So we need to have the language like lickety-split in OLS so that we can put together a non-germane amendment that's going to address the disciplinary actions of boards versus the adjudication, right? And that we're going to have the LNA career ladder amendment, that we're going to address telemedicine, telehealth, and telemedicine for professionals, including PAs, because that's part of it. We can, and I don't know if we're going to be able to get this bit of it done by then. What do you think?
I think this you could get done. We could have done this afternoon. It's actually, I think it's a pretty small statutory change with respect to the peer review only. The other items I think are a little bit more
okay.
involved.
Which those items are?
The LNA piece, the PA telehealth was proposed in an amendment that's before the Senate right now on 532.
Okay.
So it is possible that that's going to be covered elsewhere. It's actually in
Okay.
2 amendments. I know that the veterinarians and naturopathic doctors have also asked for a similar change that's also likely going to be included in those amendments before the Senate. And that was on the music therapy bill. I think the LNA piece is going to be the one that takes a little bit more time.
Okay, but we're okay with doing the disciplinary action portion of other boards? That was, remember, that was in how the original bill of House Bill 655, and we took that out but we intended to put it back in as part of our non-germane amendment. So I just want to make sure that we have something beefy after all this work.
Are you talking about the proposed repeals representative? Yeah,
yes.
that's
Okay.
something we already have in writing. We could
Okay.
get that to the committee.
And we want to make sure that all public members are independent when they're on boards because it's not specific in the mental health board statute.
Yes, you might have to make the specific change in the mental health statute if we wanted to do it the easy way that would require cleanup. You could just do a modification in our statute and clean it up later. That'd be something that we'd have to look at.
Okay. I guess whatever we need to get done by the time that addresses the disciplinary actions, the repeals of the disciplinary actions, that make sure that all public members of all boards are independent, that we address this piece, this medical review piece, and that our licensing process is objective, that there are no subjective components to our licensing process, regardless of what the board is. I just want to make sure that's another thing that we want, that is in House Bill. That was the intent of House Bill 655. So those are 4 important things. And I just want to be sure that we get that language, and I'll be glad to help with that. But I need you to help me write it. And I think that will take care of a significant part of. There was some language in House Bill 655 that was removed, and one of them was the advisory board for acupuncturists. I know we have someone. Are you from? Is this? No. Okay. So I thought that the acupuncturists wanted an advisory board. They wanted. I'm sorry. Thank you, Dr. Baker.
If there's anything else for me.
I think we're okay. Thank you. I just want to make sure. I think that I'm almost positive that the acupuncture board wanted to be an advisory board because they want OPLC to address disciplinary issues within that board. Am I?
I think there was some conflicting information from various stakeholders. And I also think there was some confusion. I know that Attorney Osterhout had a conversation with this stakeholder group, and I believe it was the association. And after that, they seemed more amenable to becoming an advisory board. The only board that I'm aware of that was interested, and I don't know that they took an official position. I would rely on Attorney Eaton to correct me, but I think it was the nursing home administrators were interested in discussing it, just based on discomfort with the disciplinary process. But I'm not aware of that being talked about subsequently.
Nursing home administrators?
They were originally an HB2, proposed to convert to an advisory board. And
did we put that back in or no?
No, the only advisory board that's in HB2 right now is the assessing certification board under 310C, which is different from the assessing standards board under DRA. The assessing certification board doesn't yet exist because they don't have any members.
Okay, so I know that this was a sort of a kerfuffle that happened, right? So the assessing standard board is going to be, we're going to take that out of House Bill 655 because they're supposed to be under DRA, correct?
The assessing standards board is under DRA, and in 655, it has that board being transferred over.
Which we don't want.
Which we don't want. One of the amendments before the Senate right now, EDNA on 532, is going to address that.
Okay, good. Let me just write down. Yeah, well, it's an amendment to 650.
Well, no, I don't think there can be amendments to 655 at this point.
Well, sorry, it's a non-germane amendment that's being attached to House, the poor music therapist bill. And so, administrator,
So presumably if it has a later effective date, it supersedes?
Exactly.
Yeah, okay.
Exactly. So the intent is not to have a committee of conference on House Bill 655. So what we passed, they passed, and whatever discussions we have will be on bills that they attached amendments to. And now the assessing certification board is addressed, but the assessing certification board is the one that needs to go back to OPLC, is that right?
So the way 655 is worded is it had the transfer of the wrong board. So it proposed to transfer the assessing standards board under, I think, 21. I'm going to mess up the citation, but it was the DRA board. And we need the board that's established under 310C to move over here. That, I believe, will be addressed in the proposed amendment to House Bill 532.
Okay, so that switch is going to be addressed in House Bill 532.
Correct.
So hopefully we won't have to think about that.
Correct. In House Bill 2, the assessing certification board under 310C is the only board that remains in House Bill 2 that's proposed to convert to an advisory board.
They don't want to be an advisory board. Have they spoken with you about this?
So I understand the assessing standards board does not want the certification board to be an advisory board, but the certification board itself doesn't yet exist. So the certification board can't obviously take a position.
Okay. So who is responsible for appointing people to the assessing certification board?
So that's a governor and council appointment. We did send out, we had a meeting with DRA regarding soliciting applications. We have an online application process where we receive the information and forward it over to the governor's office. My understanding is they did communicate that to their licensees, and I think we've only received one application. And so that's one of the reasons I believe that a lot of these smaller boards were proposed to be converted to advisory, was basically because there's just not a huge applicant pool to draw from. And the other thing I would note is that the certification board itself, or I'm sorry, the standards board, which is under DRA, is quite large. So you're already trying to solicit people to seat that board. So I think that was part of the thought process behind converting them to an advisory board.
So speaking of that, one of the things that we've talked about is reducing the number of members on boards, right? We started that process. Is that something else that we can do as a non-germane amendment? Are there any boards that come to mind that where we could reduce the number of public members or the number of members in total so that the boards can become more effective with a smaller quorum?
I think certainly some of the boards that are struggling with quorum right now should be considered to have a reduction in members and or converting to advisory board.
Okay, so we'll talk about that.
Okay.
Does the committee have any other questions? Yes.
I just wanted to go back to the medical review subcommittee part, and that is, as I understood it, the general idea is that OPLC would handle the investigation and then the boards would do the adjudication. So I had similar concerns, Representative Grote. I'm like, if that's the case, you want to keep things separate, how does it make sense for the medical board even to be appointing the people on this? I mean, I don't know if there's, if OPLC could find people or some other thing, but that just seems not quite with the spirit of keeping them separate. So I'm just wondering what the thought was behind that.
So our thought process is we want to be collaborative, and I don't think that we considered it from that angle. I don't know that the Board of Medicine did either. From the agency's standpoint, we would, if the committee is concerned about that, I think what you could do is have the board establish what specialties or what they need on this committee and have OPLC do the actual appointments. You could bifurcate that arrangement to make it crystal clear that the board doesn't have any hands in making the appointments. I think from our perspective, what we just want is some accountability and some ability to have people transition off the board if they're not being productive and attending meetings.
Okay, yeah, I mean, that seems like a separate thing, which certainly makes sense. One question on this board, I mean, is this a volunteer thing? Are these people paid? How does this, and is that going to stay the same?
It's voluntary. They do receive a small per diem. I think it's like $100 a meeting. Obviously, nowhere close to reimbursing them for the cost of losing a day's worth of work. I think that's something that we could explore. I think that's also something that could be addressed through rulemaking. You know, what the qualifications are, what you would receive for reimbursement, and I would say that from a litigation standpoint, it's not uncommon to pay experts $250 to even $1,000 an hour. So, I mean, $100 a day or $100 a meeting versus that. I mean, that could be why we're having a hard time getting applicants.
Right, I'm not pushing at this point in the process with not much time to do something about this, but maybe something to think about for the future. I don't know. Thank you.
So, when do you think we could have the language for these things? Want me to remind you of the list? I can certainly meet with you to make sure that because I'd like to have the language for the committee or for the next hearing on Friday.
Monday the 22nd.
Well, Monday to the 22nd is the
So
hearing.
the language would need to be here by.
The Friday before.
Okay.
What day
We
is
can do
that? The 18th? I'm
Doesn't matter.
terrible with
Friday before the 22nd.
the 19th. The 19th. Okay, so that means that we needed to OLS by the 18th, right? I hope there's no, or the 17th. We'll figure it out.
Okay.
Okay.
That time frame shouldn't be a problem,
Right.
Representative.
Okay, good. Is there anything else that the committee wants to discuss at this time? Any questions? Yes, Representative Schuett and then Representative Schmidt.
Yes, I was just checking and I thought I recalled a bill that I think is going to help the boards meet, and that's House Bill 308 in Senate Judiciary, which will allow some members to attend remotely. Do you agree that that's likely to help with this backlog on some of the boards?
I think it would certainly help. Yes, I think if more people could attend remotely, that would certainly help.
Representative Schmidt.
Thank you, Madam Chair. So it seems to me that these investigatory situations are, I have a question about that because it seems to me that most of the things are going to be involving things like substance abuse situations or ethical situations. It doesn't seem to me that very often you're going to have situations that you're going to be investigating plumbers that can't plumb or electricians that don't know that black goes to black and not to red and so forth. Technical questions, doctors that don't know how to that you have to do X first and then Y and not the other way around. Must have some experience already where you know what percentage of complaints involve people who are simply incompetent in their trade or profession, and other people who have got other problems. Either they're bad billers or they're bad record keepers and so forth. It's more that they have personal failings, and therefore it's going to involve how you set up the boards. If the OPLC is going to be doing it, clearly you're not going to have expertise in how the professions, in other words, how plumbers plumb, and how OBGYNs deliver babies. it's going to be about ethical failings or things like billing, maybe stealing from a client or a customer and so forth. And you presumably have some experience at this already, so that you have, because otherwise you're going to have only doctors know how to do the medical side of things, and electricians know how to do the electrician side of things. So it's going to be a big difference what kind of an investigation you're going to conduct. No?
I think it's very similar to how a civil case is handled in the private practice. For example, in a medical malpractice claim, lawyers work up the case. Lawyers don't typically know medicine, but they know that they have to talk to other people, and they need to obtain the expert qualifications in order to determine whether there's been a violation of the standard of care. But the physicians are not running the investigation because the physicians know their expertise and their expertise only. They're not going to essentially depose witnesses and gather facts. And so that's how we handle our cases. We get our case, what is the complaint? Is the complaint a substance use issue? We typically work with PHP, Professional Health Program, if that's the issue. Is it an ethical violation? If so, maybe it's plainly stated what the ethical violation is and you don't necessarily need expert testimony. Or is it this person was grossly negligent? Because pure negligence typically won't get you there to misconduct. And if that's the case, you certainly need expertise on that. And on the trades issue, we don't see that a lot, but we do have inspectors in-house. And we always have the capability of recusing a board member if we absolutely need it. As of late, we've contracted a lot for experts so that we don't need to make those requests of various boards. But part of legal training and background is to know what you don't know and when you need expertise and what requires expert qualifications and expert testimony. So we are already utilizing that process to some extent.
Follow up on a different subject. So the thing is, with regard to the Assessing Standards Board and the Assessing Certification Board, this was just a screw up, to put it bluntly, where this was supposed to go. The Assessing Certification Board was supposed to be, it was a brand new board that was supposed to be set up under OPLC to handle certification issues to some degree, disciplinary things, and initial licensing things. And the Assessing Standards Board was supposed to stay with DRA where it had always been, and instead they got switched. Okay, so the babies went home with the wrong parents, and so, but it should. I think we should make sure that we have input from the assessor or somebody who caught this mistake in the first place. Okay.
I think we've got it under control. Thank you.
Well, it is under control, but only if you know that it was just a simple.
It was a complete goof. It's a goof.
I know
it's
that.
okay. We're all allowed a goof. Okay. Is that it? I think we're done.
Thank you for your time.
Thank you. I close the hearing on the work session. Thanks so much.